Recovery. And today is all about property and health and safety legal updates, really. So my name is Corinne McGuckin. I'm the Economic Development Manager for Ards and Northern Borough Council. And it's part of our work here, to support our local companies, to look at business recovery. So this is what we're doing as part of these seminars. This is the first of 2 seminars that we are hosting, and the next one is next Tuesday. So please feel free to look at our website, for more details. But this particular seminar here is looking at legal considerations for commercial tenants in health and safety, as well as employment law considerations. So today, we're in partnership with Tughans, and so we are joined with our 2 experts, Joe Moore and Neil Smyth, and they will take you through 2 presentations. And we also have Katrina Gong, who will be coordinating the sessions. So at the end of the presentation, you will have an opportunity to ask questions, and you can actually, during the session, if you look at your screen on the bottom right, you can actually use the box to send any questions that you have, and we will put them through to our 2 speakers. So that's all I want to say at this moment in time, and we'd like to start the session, and please just let us have any questions that you might have, and we will start with Joe now. Thank you very much.
Okay, good morning, everybody. Thanks, Corinne, and thank you to Ards and Northern Borough Council for giving me the opportunity to speak to you on this webinar today. As Corinne says, my name is Joe Moore, and I'm a partner in the real estate department at Tughans. And I look specifically at landlord and tenant issues. I think it's fair to say that the issues now facing property occupiers and owners are really very novel. We're all trying to play catch up across all industries. In the legal world, our existing legislation, case law and legal drafting had been ill-equipped to deal with the fallout. However, government has rushed through some new legislation, and lawyers have adopted new approaches to drafting to provide some cover for the risks identified to date. So as a firm, we've received numerous and varied queries in relation to property matters in light of COVID-19. And I think it's useful for me to cover the main concerns we've seen and how we have answered them so far. If I don't touch on all of the issues in this short presentation, there'll be an opportunity at the end to raise any questions if you're happy to do that on a group setting. If not, please don't hesitate to contact me direct, and contact details will be available at the end. You can get in touch through the usual channels. Kat, if you could just pull up the next slide there, please. So the first and most obvious query that has been raised, and you will all no doubt have considered this already, is around the obligation as tenant to pay rent. In the early stages, some tenants had contacted us with their proposal not to pay rent at all, particularly in the wake of the full lockdown. And some of them referred to the government's then daily briefings, which were televised, that suggested there would be a moratorium on forfeiture by landlords, and that this would therefore provide them with an argument not to pay rent. So just to clarify that point, the Coronavirus Act 2020 was introduced during the summer, and it places a moratorium on landlords being able to forfeit leases. That is, it restricts their ability to retake possession and control of your premises. And this moratorium initially covered the period up until the end of June and has since been extended now until the end of September. However, tenants should be conscious that rent still remains contractually payable. If tenants don't pay rent, interest is likely to accrue on that unpaid element of rent, and landlords, of course, will have the right to pursue full payment and potential forfeiture once that moratorium comes to an end, which is currently scheduled for another 6 weeks' time. So the option of burying your head in the sand and not paying any rent isn't to be recommended. And instead, what we recommend is for tenants who face difficulties discharging their obligations under the lease, is for those tenants to try and negotiate rent concessions. One approach we had seen was to seek a rent holiday while the tenant could not access its premises at all. Another was to seek a rent reduction for a temporary period. And yet again, we've seen some landlords and tenants agree to convert fixed rent to turnover rent. Now that is an interesting and newer approach that we've seen recently. and that sees landlords essentially sharing the risk with tenants. So as retail is reopening and there remains much uncertainty about high street footfall, this sharing of risk has great advantages for tenants. It's also an indication that the landlord is taking a more long-term view and sees the benefit of helping tenants ease through the current difficulties in the expectation that they will return to full rental payments again in the future. Another approach we saw from tenants was to write to landlords and, based on cash flow projections, seek consent to pay rents monthly in advance as opposed to quarterly. And of course, this is a much more palatable request for landlords and likely to be accepted in many circumstances. At all times then, the importance of achieving agreement with your landlord and engaging in those discussions is paramount. Tenants will need to be careful to avoid breaches of lease, which may negate future break options or may impact other concessions that are being enjoyed, but which are dependent on full compliance otherwise with the terms of the lease. So as I've said before, it's important to achieve agreement from your landlord to avoid him using any current breaches against you in any future dispute. So I've spoken there about the approach to payment of rent under the lease and the ability to perhaps achieve a concession of some kind. And that discussion relates to the main annual rent. And I think it's important for tenants to work with landlords as best they can. With that in mind, I recommend that tenants don't seek any rent-free or concession in relation to service charge rents and insurance rents. The reason being that the services will still be provided for the benefit of the building. Insurance will still be provided for the benefit of the premises. And I think it's important, therefore, to contribute to those costs to ensure that both the services and the insurances are still provided by your landlord and that he can afford to do so. It would, of course, be useful to discuss with the landlord the possibility of reducing certain services to limit those costs, but the contribution should be maintained as far as possible, in my view. And if you pull up the next slide, please, Kat. So, having said all of that, it's interesting that the distinction then between the main rent and the service charge or insurance rent has not been made in the drafting of the Coronavirus Act 2020. Now, I've put up section 83 on the screen. I appreciate it's maybe not very clear to read, but that section deals specifically with business tenancies in Northern Ireland and the protection from forfeiture for non-payment of rent. And rent is specifically defined in subsection 7 there as including any sum a tenant is liable to pay under a relevant business tenancy. So any sum is the key phrase. That therefore means all payments due to the landlord or indeed any third party, for example, rates, electricity, etc. So it's important to recognise that these protections from forfeiture are afforded to business tenancies and leases as well, specifically defined. And there's a whole separate discussion can be entered into as to what constitutes a business tenancy. But essentially under the Business Tenancies Northern Ireland Order 1996, you will achieve those protections if you are a business operating under a lease of term certain of more than a year, or you've been in exclusive occupation for more than 18 months. So for the purposes of this discussion, we'll assume that everybody comes within that, that definition. As I've said, the protections from forfeiture relate to the non-payment of rent only. It doesn't cover you for other breaches under your lease. And we'll look at that again later on. But this relates to non-payment of rent only during the relevant period, which I've said currently takes us up to the 30th of September, and there's the possibility for a further extension. Legislation then stops landlords from achieving forfeiture or re-entry during that period, but the legislation specifically says in subsection 2 that no conduct by or on behalf of a landlord other than giving an express waiver in writing is to be regarded as waiving the right of re-entry for non-payment of rent, which essentially means that landlords can pursue forfeiture after the end of September. So as I say, in another 6 weeks or so currently, unless that's updated further. So it's important to focus tenants' minds on the fact that these are temporary restrictions and protections against forfeiture, but there's still the obligation to ultimately pay the sums due under the lease. And there are other specific drafting points within that legislation, but for the purposes of this morning's brief seminar, we'll not develop that further. So if we look on to the next slide, please, Kat. At this point, I think it's useful to also quickly touch on some developments in insolvency law. The pandemic has spurred an expedited legislative change in our insolvency law in an attempt to reduce an influx of COVID-caused winding up petitions and statutory demands, which can be used by landlords potentially to force payment of rent where, for example, the moratorium on forfeiture is impacting them. So the Corporate Insolvency and Governance Act 2020 received royal assent on the 25th of June this year, and that makes specific provision for Northern Ireland under sections 4 and 5. A key change to note under section 4 is the introduction of another moratorium, this time on the effect of presenting a winding up petition as something of a grace period. And essentially that's an initial 20 working day period granted with provision for further extension on that, which offers companies protection from creditor action whilst they seek professional advice, generally to give them some breathing space, explore further options, or to consider financial restructuring. A moratorium will be granted to companies that are unable to pay their debts when they fall due, so long as they have a statement from a licensed insolvency practitioner that states that the company has a good chance of survival. Throughout this period, the licensed insolvency practitioner, to be known here as a monitor, is to be appointed for the company, who will oversee the period and ensure that the company is acting within the framework of this legislation. And during this time, a company is not then obliged to pay pre-moratorium debts, so that's debts either before or during the moratorium period, which gives them something of a payment holiday. However, from a property perspective, let's see how this interplays again with the Coronavirus Act. It is important to note that the company still remains ultimately obliged to pay the rent during the entire period. But crucially, the new legislation also temporarily renders statutory demands served between 1st of March and 30 September as null and void in terms of using them as a means to present a winding up petition to the court. So again, another angle that landlords can take to try and force payments. The legislation also makes clear that between the 27th of April and 30th of September, in order to make a winding up petition valid in a case of insolvency, a creditor must prove reasonable grounds for believing that A, the coronavirus has not had a financial effect on the company, or B, the company would not have been able to pay its debts even if coronavirus had not had a financial effect on the company. So in summary, I suppose what we're saying on this new legislation is that if you're faced with a potential insolvency action, be served with a stat demand or be threatened with a winding up petition, ensure you engage immediately with a specialist insolvency lawyer to chart a path through what is a very complex field. And we do have a dedicated team in Tughans who specialise in this area. So if we look on to the next slide, please, and termination. So looking beyond just the rent queries and considering other concerns within the landlord-tenant relationship, some people have been looking more drastically at their options and asking whether COVID-19 can be used to bring their lease to an end early, or if there's some ability to simply walk away without any further obligation to your landlord. And some of those questions have touched on the legal doctrine of frustration or the ability to call upon force majeure clauses. So looking at these from a property perspective, and in that context, the doctrine of frustration for a tenant is an argument that it is impossible to perform the contractual obligations under the lease because of the global pandemic, therefore bringing the lease to an end. But it's widely accepted that the bar is set much too high for any tenant to successfully argue that position, to say that the lease is frustrated, comes to an end. And that recent case of Canary Wharf Limited and European Medicines Agency in 2019 was a case brought on because of Brexit. There was no further requirement for the European Medicines Agency to maintain premises in London. And they argued that because they couldn't continue in operation in the United Kingdom post-Brexit, the lease was necessarily frustrated. But they were unsuccessful in that argument. Turning then to force majeure, that is a clause that essentially the drafting provides that the obligations on each party are terminated where they are prevented from performing their obligations. And to rely on such a clause, you'd need to have the relevant force majeure drafting in your lease. Unfortunately, that type of drafting wouldn't as standard appear in leases. It's not something that's going to be largely available to most tenants. So if we're looking at abilities to terminate, you could then turn to the lease itself and see whether there is a tenant's break clause available. Quite often a break clause will require 6 months advance notice in writing to your landlord, full performance of all tenant obligations under the lease in order to implement the break. And that kind of timeline, those kinds of obligations are unlikely to be helpful for a tenant who's facing difficulties in the short term. So if you don't have an ability to walk away based on current legislation or case law, and you don't have the ability to break your lease and walk away based on the drafting of the lease itself, then the next option is pretty much what my constant refrain. It is negotiating with your landlord. So it's trying to take negotiations forward with your landlord, see if you can reach a commercial agreement. There's always give and take in those negotiations, and it very much depends on each individual set of circumstances whether that will be achievable and you get the outcome that you seek. So the next slide then, please. While we have seen the introduction of legislation to combat some of the effects of coronavirus and also seen some new practices in lease drafting, many of the current concerns are best addressed through open communication with landlords, through trying to negotiate sensible proposals with landlords. And I accept that not everyone will approach those discussions with a sensible head, but where you can achieve agreement with your landlord, it's essential to document that agreement, not to rely on a wink and a nod or an informal spoken arrangement. So any variation to your lease, even a temporary one, should be recorded in writing, should be articulated accurately and clearly, and it should cover with accuracy the exact concession that is granted and the period during which the concession applies. You should consider whether the variation to a lease agreement requires you to vary any other related agreement, whether that be with a landlord or another third party, perhaps a subtenant, a licensee, or even a lender. As a tenant, it's important to be careful that your variation isn't deemed by HMRC to be a surrender and re-grant, which could trigger a hefty stamp duty land tax liability. So, for example, we have seen some tenants achieve a 3-month rent-free. That was more so at the start of this, these restrictions and lockdown. But in return for that 3-month rent-free, what we had seen on occasions was that the landlord tacked a further 3 months on to the end of the lease, so that the landlord was still collecting the full amount of rent roll, but just over a slightly longer period. Now, there are a number of ways to achieve that outcome, and the landlord's solicitor will most likely be doing the drafting. If a tenant doesn't engage his own solicitor, then that drafting could be produced in a manner that is very disadvantageous for a tenant, not necessarily through overt intent, but that can be the outcome. So if a landlord simply prepares a deed of variation stating that the term is now to expire 3 months later, the effect of that is a surrender and re-grant, and the tenant is then obliged to submit a fresh SDLT return and make a full stamp duty land tax payment to HMRC. That's an unintended consequence of one approach to the drafting, and it can be very expensive. So I would say that the correct way to approach this proposal for a tenant is to take a reversion release commencing at the end of the current term and enduring for 3 months in total. Now, I appreciate it sounds odd to take a full new lease for such a short term, which will occur at a future date, but that can be achieved in quite a short document. If properly drafted, this approach avoids the SDLT, the stamp duty land tax implications that I have just set out. And then if we just move on to the last slide, please, there, Kat, looking at new leases. Bearing everything in mind there, if you're currently negotiating a new lease or a lease renewal, all of those considerations must be brought to the fore. It's been indicated that there is the potential for a second wave and the imposition of fresh restrictions, perhaps on a local level. And if that is true, and none of us know, then we could be facing more lockdown scenarios again in the future. So in drafting and negotiating a new lease, consider whether you should have some sort of rent suspension drafting for another COVID-19 type pandemic or an extension of the current pandemic, further restrictions. Look at the service charge provisions, whether services should be drastically reduced in the event of closure of premises. Look at rent-free periods, which are being granted at the start of a lease to allow for tenant fit-out. If lockdown stops you or temporarily stops performance of the fit-out, then should your rent-free period be extended accordingly? Consider break options in the event of further COVID-19 type disruptions. Landlords may not accept these proposals, but it's important to remain alive to these concerns now that we have gained experience of the pandemic to date. That's just a very quick run through some of the property issues worth bringing to the fore. I'll pass across to Neil here now, and he'll look at health and safety matters.
Thanks very much, Joe. As Joe said there, my name is Neil Smyth, and I am a partner in the insurance department in Tughans, and I'm going to deal with health and safety considerations for employers and businesses and the framework surrounding their duties in relation to those. Since becoming a notifiable disease at the end of February 2020, COVID-19 has posed unprecedented challenges for businesses and employers in Northern Ireland. Despite these challenges, an employer's legal duties to take reasonable care for the health and safety of their employees and any third parties on site at their premises remain. These include customers and suppliers alike. Given the unprecedented nature of the current situation, there is obviously limited case law on the area, but duties to an employee of any third party on site remain where these risks could have been mitigated by an employer taking reasonable steps. Failure to take these reasonable steps could potentially result in civil liability as a result of claims from impacted parties and or even criminal liability if a matter is investigated by the Health and Safety Executive for Northern Ireland. In that light, it's important that businesses and employers have an understanding of the legal framework around their duties and liabilities vis-a-vis third parties and employees present on the business premises during the pandemic. This is in regard to the risk of those parties contracting COVID-19 on site, as well as the potentially relevant insurance policies upon which businesses might rely in defending any related claim. It's a fast-moving situation, obviously, and the government guidance to businesses is evolving on a daily basis practically, and therefore it's important that all business owners and managers should ensure that they keep up to speed with all guidance provided by the Health and Safety Executive of Northern Ireland, the Public Health Agency for Northern Ireland, Public Health England, and also the governments of the UK and Northern Ireland. So Kat, you can maybe put up the first slide there, which deals with health and safety duties of employers. I'll touch on that a bit now. All employers in Northern Ireland have a non-deliverable duty to ensure a safe place and system of work. Accordingly, employers must take reasonable and necessary preventative and protective measures to ensure the risk of exposure in the workplace to their employees is minimised. It is reasonably foreseeable that if such measures are not taken, this may result in an increased risk of employees becoming infected, either by other employees or by third parties. Employers have a moral and legal responsibility to look after the health and safety of their staff. As an employer, you also have a legal responsibility to protect workers and others from the risk to their health and safety. This means you need to think about those risks which are faced and do everything which is reasonably practical to minimise them, recognising at all times that we just simply cannot eliminate the risk of COVID-19. I've highlighted here in the slides, you see some of the regulations that employers must comply with in terms of their health and safety duties towards the employees. Their duties aren't limited to these regulations, but these are some of the most important ones. These regulations were not written with the current situation in mind. However, the statutory obligations are particularly critical in the current context. Therefore, when an employer considers the guidance and recommendations made by the government and the various agencies referred to above in relation to the pandemic, they must also ensure that they comply with the regulations when putting in place all protocols designed to protect employees. For example, Regulation 3.1 of the Management of Health and Safety at Work Regulations, Northern Ireland, 1999, deals with risk assessments, and that provides that every employer shall make a suitable assessment of the risks to the health and safety of its employees and to other persons who may be affected by the working activity. With specific reference to the current COVID crisis, each employer must limit the risk of exposure for its employees in the workplace and manage the situation of an employee who has been infected or in touch with an infected person. Risk assessments should be carried out by employers, and they should specifically address these points. If you're looking for an example risk assessment, the HSE NI website is a good place to start with. There's examples there. A risk assessment, it must be remembered, is not about creating huge amounts of paperwork, but rather about identifying sensible measures to control the risks in your workplace. If you have fewer than 5 employees, you do not have to write anything down, but it might help if you do, and it'd always be our recommendation to put everything down on record and commit in paper your thought process behind risk assessments. Considering this in relation to the pandemic, risk assessments will need to be kept under close review to ensure that they are effective in practice and they are responsive to the likely change in law and guidance as restrictions are either lifted or tightened again. Another good example, Kat, if we move to the next slide, please, is Regulation 4 of the Personal Protective Equipment at Work Regulations, Northern Ireland 1993, which deals with personal protective equipment and is a duty on an employer to ensure that employees are provided with PPE in a situation where they're exposed to a risk to their health and safety while at work. The ongoing pandemic is rapidly evolving, and the measures that will be required for every business or employer will most likely be different depending on the nature of the business and the contact with is also a very live issue, and it's certainly a live issue at the minute in the south of Ireland with certain outbreaks in meat factories. And a lot of clients have asked me about whether or not they have to report certain things under the written obligations. The Health and Safety Executive has issued guidance on reporting of cases of COVID under the 2013 Reporting of Injuries, Diseases and Dangerous Occurrence Regulations, i.e. the written regulations. The guidance states that a report must be made if an unintended incident at work has led to someone's possible or actual exposure to coronavirus, and this must be reported as a dangerous occurrence, or an alternative, a worker has been diagnosed as having COVID and there is a reasonable evidence that it was caused by exposure at work, and this must be reported as a disease which is distinct from a dangerous occurrence. Examples given by HSE in their website relate to workers who are directly in contact with situations which are deemed more dangerous, for example, viruses in a laboratory or in a healthcare setting. Therefore, it's not envisaged that every case of COVID-19 in the workplace should be reported, and detailed consideration must be given to the individual circumstances on whether a report should be made. Businesses should follow industry-specific guidance to manage the workplace environment, and, for example, invoking social distances where possible, and this will obviously limit the likelihood of a written report being required. The HSE also identifies employers which are not taking action to comply with the relevant law and guidance. For example, employers who are not taking appropriate action to socially distance or ensuring that people who are in the vulnerable category are self-isolating. And in that situation, the HSE will consider taking a range of actions to improve the control of the workplace. This will range from the provision of advice to employers or through issuing enforcement notices to help secure compliance. A question clients have often been asking me over the last few months is whether they're potentially going to be sued if an employee is infected. It's a difficult question, but in establishing whether or not an employee contracting COVID will expose a business to a risk of claims, the employee would need to establish on the balance of probabilities that this was a work-related accident. In defending any such claim, there may be evidential barriers for any employee to establish that he or she contracted the virus through the workplace contact. If there's only 1 or 2 isolated cases of employees contacting the virus, employers or businesses may have some basis to defend any prospective claims. This is obviously on the basis that there is no evidence that the employee was infected at work, and also the employer can introduce evidence that the procedures and preventive measures the business put in place were appropriate in the circumstances to discharge their legislative duties. These evidential hurdles may be reduced when the employee is able to demonstrate, however, that as part of their claim, they have had limited or no contact with other people outside the workplace. In any situation where there's a cluster of infections which could be linked to a single business, it would be significantly easier for an employee to prove that they were infected while at work. If so, the courts may accept that this is a work-related accident or occupational disease, and in order for an employer to defend a claim or claims by employees, it would have to prove that it discharges duties by taking all reasonable steps to prevent the risk of infection. It's also vital that in that situation, it's also vital that in a situation that an employee should display symptoms of COVID and/or test positive for COVID, that the employer responds appropriately within the relevant statutory guidelines to deal with the situation so as to ensure that cluster cases do not develop, minimising the risk of exposure to employers' liability claims. So therefore, it's very important that in situations where there is an example of someone testing positive in a workplace, that the employer acts accordingly and proactively. If you move to the next slide now, Kat, I'll deal with health and safety duties on occupiers. This deals more with the retail section. Business owners have a statutory duty of care to third parties who visit its premises under the Occupiers Liability Act, Northern Ireland 957, more specifically Section 2 of that Act. It's expected that a visitor will be reasonably safe in using the premises for the purposes for which he or she is permitted or invited to be there. Businesses also have a common law duty to visitors who attend its premises that they do not suffer injury or damage as a result of negligence. The duty, therefore, on business owners or management is to take reasonable care, i.e. to establish that all reasonable steps have been taken in the circumstances to make the premises safe. It is vital that this can be demonstrated through method statements, risk assessments again, and any signage displayed to visitors. There should be sufficient warnings to visitors to warn of danger and/or mandatory steps to mitigate the risk. A system should be implemented so social distancing in line with the governmental guidance of 2 metres can be established, and where not possible, alternative arrangements such as screens are erected. Hand sanitisers should be provided at the entrance of premises and situated in prominent positions throughout the premises. Since the 10th of August, everyone's aware now that face coverings are mandatory in shops and shopping centres. Before this date, it was only mandatory in public transport in Northern Ireland. It is not mandatory to wear face covering in a business that is able to maintain social distancing by using a ticketing or appointment system. This might include, for example, cinemas or hairdressers or certain restaurants. You don't have to wear a face covering also if you're under the age of 13, if you're a member of staff or employee of a shop or shopping centre, if you're temporarily asked by a member of staff or a member of the PSNI to remove it to check your identity, or if you have a reasonable excuse not to, which could be in the form of a letter from either a doctor or a government. An employee of a shop or shopping centre can tell you to wear face covering and can tell you to leave the shop or shopping centre if you refuse to wear one, or if you do not have a reasonable excuse not to. It's important to note that face covering and masks are not classified as PPE, and therefore there is still an obligation on employers to review face coverings and masks worn by employees in conjunction with the risk assessments and to ensure that they are suitable. PPE protects the user against health and safety risks at work, and it includes items like helmets, gloves, eye protections, potentially face masks. But the experts largely agree, however, that face masks are there to protect others and not the wearer, as with PPE, against the spread of infection as they cover the nose and mouth, and therefore it's important not to get a false sense of security about the level of protection they may offer. Businesses should take reasonable steps to encourage customer compliance in relation to the wearing of face covering, for example, through in-store communication or notices at the entrance. If necessary, police can issue fines to members of the public for non-compliance. Businesses will not be required to provide face covering for the customers, however, but some businesses and retailers may wish to consider this as an option, and some are already actively doing this. Again, many clients have been asking me over the past few months about the risk of claims being made by members of the public who allege they may have contracted the virus while on their premises. An owner or management of a premises may be found to be liable if they fail to take the reasonable steps to mitigate the risk of exposure to third parties. However, it is not enough for the third party to show that there was a breach on the part of the owner or management, but they must also establish on balance of probabilities that there is a causal link between the exposure of COVID and them attending these premises or businesses. Some commentators believe it is inevitable that claims will be made by employees and members of the public alike against business over the coming years because of infection of COVID. It's perhaps more likely in certain settings involving employment, such as healthcare, as I mentioned above, and other factory settings, such as the meat processing plants example I gave above, which is apparent in the south over the last few weeks. Most clients have also been asking me about where they are in terms of the insurance cover in relation to the situation where there's a claim by a member of the public or by an employee following contraction of the virus. I think it's very important that all employers and businesses check the current position with their EL and PL insurers and their brokers in relation to ensure whether cover is in place. If there's any doubt about this, advice should be sought from a solicitor. You don't want to find yourself in a situation as an employer or a business at some time down the line when you face a claim as to whether or not you have cover. So it's important to establish this as quickly as possible. So finally, in conclusion, it's important to understand that this is a very evolving situation, and all business and employers constantly must monitor the situation regarding the guidance being provided by the government and the relevant authorities I've referred to, and they take all reasonable steps to take this guidance into account and that they follow these steps. All practical steps should be adopted as best as possible to ensure, as far as is practical, the safety of employees and visitors alike. It's essential to undertake appropriate risk assessments in accordance with the relevant statutory guidance, and that all the recommendations or findings of individual risk assessments are implemented. Appropriate PPE should be provided to all employees, having regard to the specific duties under the 1993 regulations. It's important that all employers and businesses proactively monitor and enforce compliance from employees and third parties as far as is reasonably practical. They must also undertake continuous monitoring of the situation to include implementing a system or means to keep abreast of statutory guidance as it develops. This can be internal or external via risk assessment management businesses or a law firm. You should also develop appropriate individualized protocols for dealing with COVID outbreak based on their internal protocols and relevant statutory guidance, but tailored to their organisation and the particular circumstances having regard to the outcome of their individual risk assessments. It's important to develop reliable and effective systems for communicating with employees and third-party stakeholders. And this includes ensuring that all data is up to date and regularly reviewed, and that there is an emergency communication system in place in the event that normal means of communications cannot be used, and also to ensure that proactive messaging is communicated to all such parties via signage, email, written communication. It's important that all businesses and employers review their insurance policies in conjunction with their insurance companies and their brokers to ensure coverage is adequate. And finally, it's important that all businesses and their managers should take an active and hands-on approach to ensuring that the above guidance is implemented across the business, actively reviewing it and ensuring that it's communicated to and followed by employees and any third parties. So that's the end of my presentation today. If there's any questions from myself and Joe, we'll now perhaps put you back to Corinne and Kat so they can take forward the question and answer session. Thank you very much.
Hello everyone, I'm Kat, Marketing and BD Executive at Tughans. If you have any questions, can I ask you just use the chat function on the right hand side, or If you want, I can invite you onto the screen and you can ask the question personally yourself. So don't be shy. Put your questions up now for Joe or for Neil. You're all very quiet.
Everything was well covered.
Very succinct summaries. Let me see. I'll just invite Kareem back on.
Our contact details are free. Feel free to send an email, anything specific, and later I would be happy to return your email or give you a call to discuss. No problem.
Absolutely, Joe.
Kareem, do you have anything to add at the end?
No, at this stage, I was just hoping that, if there was any need for clarification or questions, that would be the ideal opportunity to do that now. And, if you want just, to put it in the suggestion box at the bottom, very happy for that, but I think it would be a good platform to actually have a discussion if you have something to ask. We don't need to bring you on screen, so you can just do it, just from the box, and we'd be happy to actually let, Joe and Neil answer to them. But if you feel that, you want to think about it and let us, have any questions later, of course, you can contact us individually or together, and we'll be happy to answer later on. So if you prefer it that way. So I'm just going to wait for a few seconds here to see if anybody wants to ask any questions. And no.
If, as Kareem said, if you prefer just to ask questions later, I will send a follow-up email with everybody's contact details, and you can get in touch with us and we can answer your questions afterwards if that suits, because no one seems to be putting their hands up at the minute, so probably best just to wrap up. Yeah.
So if there is no other question, then what we would like to do as well is Kat, will be sending you a form, which is like a feedback form. And if you would like to complete that, let us know what you thought of the session. Did it bring you anything? There will be a set of different questions in there. And that would be great if you could actually answer that and send it back. And oh, there is a question, I think, here. And so we can take that one. I just, finish my point here and saying that, if there is anything else that you want the council to propose in terms of topics, which are of concern to you, please just contact us and let us know that there is one particular area that you're not clear about, you would like clarification, you would like more information. So, this is our role here in economic development, to listen to you and to try to facilitate an answer, through the partners that we have, and the professional advisor and experts that we have at our disposal and who want to work with us, very kindly. So I think that, having said that, I think that Kat, you might want to take the question that's on the screen now.
Yeah, I can deal with that question.
That one's
Thanks,
for
Kat.
you. Yeah.
Yeah, thanks. I think I'm unmuted now. Yes, no, a good question. Yes, I can deal with that. Yes, the answer is yes. Local authorities, any party responsible for any area of land has duty under the Occupiers Liability Act to ensure the safety of people using that land for the purposes they are intended to be there. So the answer to that question is yes. And if there's an issue in relation to sort of council-owned land, I would recommend you get in touch with the council and explain any concerns you have, or if things are really, really bad, then the police maybe should be informed. But certainly the council have as much duty to land they own or responsible for as does any occupier. So the answer to that question is yes.
Thanks, Neil. Does anyone else have any questions they'd like to ask? Maybe something for Joe or Corinne?
Well, am I still on mute there, Kat? Can you hear me? Can you hear me? Yeah. Well, yes. Well, it's a matter for yourself. Obviously, I wouldn't recommend that people go to the police willy-nilly. But look, the council is responsible for the land. They have a duty as the occupier, and if you're not getting any response from them, then you might have to think of an alternative means to get a response. I think during this crisis, there obviously has well publicised situations where particularly young people are congregating in open areas, and that's causing some issues in certain areas. And obviously, a lot of these incidents are well reported in the media, and the police have been certainly informed of it, and at times are taking steps to try and disperse crowds, etc. If you having a situation like that which is causing you distress or issues, especially in light of the current pandemic, then that is a step you may want to take. But the council, if it's a council-owned land, they have a duty, and if you get no response to them, you may have to think going beyond them. Again, you know, I would say in a situation like that, I think that if it depends what the behaviour is being carried out. If it's antisocial behaviour, which I suspect it might be, then it may be one which is more in line with a report to the PSNI. However, you know, there's no harm in contacting certain different agencies and Health and Safety Executive again, and certainly you can make inquiries to Health and Safety Executive to ask them what the best option is in a situation like that. So I would say you have a number of options there, and it's a matter for you which way you want to take it. But certainly there is a duty there on the occupier, and if you own land adjoining that area of land, and if you're not getting any response from them, or certainly a response which is adequate, then you might have to think about that and go to certain other authorities. So the Health and Safety Executive, the police are examples of bodies you might want to contact.
And I was thinking about this question there. If you know, you can contact me, you know, at the address, you know, which is on the screen, and let me know who you contacted in the council. I could check that out for you. So that would be the best way forward, you know, to see, you know, what we can do to assist. Okay.
Okay.
Okay, thank you.
Okay. If no one has any further questions, we maybe end the broadcast. It is recorded, and it'll be available on the Tughans website and on the Ards and North Down business website. And as I said, I'll send out information to let you know how you can get access to the broadcast. And we'd just like to thank everybody for tuning in today. And again, if you want to get in touch, please don't hesitate to get in touch with the contact details available on screen. So thank you very much.
Thank you.
Thank you. Thanks. Okay. Thank you.
Thank you.